be able to talk to you about this? How would you recommend they go about it?
Like asking for like my address or my phone number, like my location share. Or I could just location share you, and then we could.
An actor who does press for a movie about such a serious topic, you gotta talk about it.
Right.
And oftentimes, that's as much as we love doing fun interviews with these actors and kind of having that moment. I always sort of use the bar of let the tone of the movie set the tone for the interview.
Hi, besties. It's Judgment Day for Blake Lively. Well, at least summary judgment day. And now, if this summary judgment is granted in full, and I don't know if it will be, but if it is, this could be a very much of a thud of an ending for Blake. But Wayfarer has come out swinging along with their co-defendants, Jamie Heath, Justin Baldoni, Jen Abel, Melissa Nathan, and Steve Sarowitz. And in the summary judgment, they go through extensively why Blake Lively's lawsuit doesn't meet the requirements for the allegations of SH, why she wasn't a contractual employee, why she was a contractor, why she never signed her contract, so their contract was never fully executed, how much control she held over the production, that she was never an employee. There's so much in here, and I was pretty blown away as I was reading through it this morning because I was of what the issues were in the complaint. And this is a lot of what we've been talking about, and it's impressive to see it in such a robust document. Now, again, I'm not sure that all of this is going to get granted, but I think they've made some really good arguments, and we'll have to see how Blake's side responds. But what they've also done is put out a ton of evidence. I mean, there were more than 200 attachments to this motion. Now, a lot of them are filed under seal, and those documents being filed under seal are only under seal for 1 week. And Blake will have to go through and decide whether or not she wants to keep these under seal. Right? They did state that they felt, Wayfarer, in a letter to the judge when sealing, that they feel like everything should be public, including Blake's deposition testimony, because this is such a big dispositive motion. And if you recall, the judge previously had unsealed documents that were connected to dispositive motions because of the need of the public to understand what evidence is being used to make the decisions that are being made. So they're really saying we only want to keep sealed what is confidential, truly confidential, but we don't feel like anything that Blake really has put under seal is truly confidential. And also to note, Wayfarer, including Justin, Jen, Melissa, and Jamie, along with Steve, they've unsealed their deposition transcripts. And so you can see parts of them, not the full transcript, but at least parts of them. So you can hear from Justin and Jamie and Jen and Melissa and Steve for the first time. All right. And what I really like, before I even dive into this, I just want to say something. Like, this is written by Alexandra Shapiro. And one of my main criticisms of their complaint against Blake was that a lot of it was just like explaining away and sort of like blaming her. And it felt like, even if she's lying, it's like, oh, she's just a liar, right? And this is what really happened. And what I like about this response is it's not about saying she's a liar. It's about saying this doesn't meet the requirements, right? It doesn't even discuss if she's a liar in some of these claims. It's just that this doesn't meet the burden, or this isn't to the standard of what SH is. So it takes out some of that, what would be perceived as victim blaming language that was criticized of Justin Baldoni. And so I think they've taken into account the optics of what this case is. And I think that's good for all of us who have been victims, because it doesn't come at us and make us feel like we are the liars. It's really going into, does this meet the requirements under the law of what a claim of SH actually is. Okay. But one of their main arguments here is that she was the one that held a lot of the control, and that her claim now that, this was about them having control over her really fails because they held no control. And one thing that's required in a claim of SH is the power dynamic. And so a lot of what they've done in this summary judgment is going through that power dynamic that they claimed she held, and they were actually more inferior to her. So they started off by saying she was an immensely powerful A-list actor. I think they're being very generous there. Agreed to act in a film adaptation of It Ends With Us, a book of themes of sex and domestic violence. During the initial stages of the filming, she voiced objections to certain on-set behavior she did not like. That behavior, involving no more than miscommunication and awkward comments, falls well below the threshold for any claim of sexual harassment or any other legal wrongdoing, especially in the context of collaborating to make sensual and provocative sexually charged films. Regardless, Lively's concerns were heard and fully accommodated. It is undisputed that whenever she claimed she had experienced ceased. Filming continued during all future stages entirely without incident, and an environment Lively touted as, and then it's all blurred out. But they point out that said even Lively's then lawyers said no formal HR process, let alone litigation, was necessary, and any issues had been successfully resolved. So what that sort of sets the stage for all of us that what this is about is not about fighting with her about if it happened. They agree some of these things happened. They go into, does this meet the criteria of what actually is sexual harassment, right? So they said months went by, but as the film was edited and moved towards its premiere, something else happened. She asserted control of the film and took aggressive steps to minimize his role, Justin's role. Even though Baldoni had conceived, directed, and co-starred in the film, it had been produced and co-signed by his production company, Wayfarer Studios, and Lively took all the credit. She wrote to the Producers Guild, so they share whatever her letter was to the Producers Guild. And then at the same time, Lively and her actor husband, Ryan Reynolds, disparaged Baldoni to their famous high-powered friends in Hollywood and to Baldoni's talent agency. As the film premiere approached, she became increasingly hostile, including she excluded Baldoni from marketing materials, press promotions for the film, and snubbed him on social media, which urged Sony to eliminate his film buy credit and even tried to exclude him from the premiere. In light of these astounding developments, and not the minor concerns about the on-set behavior raised and successfully resolved many months earlier, Baldoni sought the advice of a crisis management public relations firms, as any responsible person in his position would do. He wanted to minimize fallout from media coverage of Blake's increasing attempts to alienate him from the film. He did so for the benefit of both his professional reputation and the newly released film. He relied on the media professionals to boost his image and assure that any coverage would be balanced and accurate. None of this is against the law. Aided by two of the world's largest litigation firms, Lively now seeks to create causes of action where none exist. She cannot show the behavior she disliked was caused by her sex or gender, a basic prerequisite of sexual harassment claims. She alleges Baldoni's resort to public relations professional was retaliation for complaints she had raised. This ignores the large temporal gap, and not to mention that many intervening events between her raising of concerns and Baldoni's resort to crisis management professionals. There can be no claim for retaliation based on purported complaints raised in the distant past. Nor did Baldoni and his co-defendants engage in any defamatory smear campaign. It was not illegal for Baldoni to promote positive content about himself or truthful narratives about various events. That Lively's reputation may have suffered as a result of her own ill-advised public statements and actions. This is a dispute about Hollywood reputations, not genuine legal wrongdoings. It does not belong in court. A huge part of the summary judgment is just going through the statements of what the facts are. Okay. And so with a summary judgment, it's super important for all of you to understand that a summary judgment isn't different than a motion to dismiss. A motion to dismiss is about the law doesn't support this, but a summary judgment is saying there's no dispute about what happened. And so there's nothing for a jury to decide. All right. It will weave in legal matters as to why it can't go to the jury or why it doesn't belong in the court, but it's really getting to the facts of this case. And if there's no disputes about what happened, there's no actual dispute that needs to be determined. There's no remedy that needs to be resolved. And they go into the various incidences that Blake has claimed are sexual harassment. They argue that these incidences are not what meets the legal standard of sexual harassment. You can consider like that she claimed she was fat shamed, or that Jamie walked into her trailer, or that she was shown a video of a birth and she claimed she thought it was porn. She thought she was fat shamed because Baldoni asked about her weight, or she was quote unquote sent to a nutritionist to help her lose weight, which these are all the different aspects she has claimed have been sexual harassment, or hugging on the set, or calling her sexy, or calling Jenny Slate sexy. And then it will go into her contract of what was her contract? Was she an actual employee? Or was she an independent contractor? Did she even sign her contract? Can we even enforce the terms of her contract to claim that she's an employee? How much control did she actually have over this film? How much did she control us versus us, us controlling her? Because that's a key part of determining if someone is your employee. And discrimination laws under federal law are only for employees. So other details are, well, once she did bring up all of these issues, she sent us this letter that included a list of protections. And her own attorneys in this letter of protections told them that this would suffice. If you can agree to this, this would suffice in lieu of a formal HR process. And that she didn't commence any litigation or file any formal complaints, but that her lawyer said that she reserved all legal rights. They're saying that even her own lawyers agreed that this didn't meet the legal burden of sexual harassment, because if it did, their argument is they would have gone to HR and they would have gone through the formal process, but they didn't. The argument is also going to surround about, can we enforce this protections document if she didn't sign the overarching actor loan out agreement, which that was incorporated into? It's a side letter amendment to the wider, larger actor loan out agreement that she was required to sign and never did. So how can you enforce it if she never signed it? How can you actually enforce something that's incorporated into it when you've only signed one part of it? You failed to sign the full contract. So it's going to be part sort of like, is it sexual harassment? Is it contract? And then we go into the contract law. It also dives into, how she agreed that once everything was addressed, nothing else happened on the set. And that really what actually changes things is that once they wrap, the next conflict comes up, and that conflict surrounds around creative control. And that's when they claim that tells Sony, like, I'm not going to do this premiere. I'm not going to promote your film unless you let me edit it. And that, she also writes a letter to the Producers Guild, which apparently tells them all kinds of things about how much control she had in the film. And then the other aspect is it really retaliation if Justin's just defending himself? And if Lively is also stirring up negative press about him and the film, doesn't he have a right as a studio and as an actor in the film and the director to defend himself and protect the film and protect the studio and his own reputation? And the reason why he claims he has to hire crisis PR is because of the fact that Blake had alienated him from the premiere, and that it was obviously going to create questions within the media. Fans were going to notice and they unfollow him. And his motivation here is that they need to be able to be prepared for what comes out if she continues on this tirade against him. And he's trying to minimize the damage of what could happen to this film by this negative publicity related to him being isolated from the premiere. So from their view, he's hiring Melissa Nathan not because of a protected activity. He's doing it because by the point of the premiere, he's told not to come. She's unfollowed him, and there's already like all these people online talking crap, and it's creating bad PR for the film. And then obviously we know that she starts getting backlash, and a large part of that is because she's got a big name, and that instead of her being smeared, they point to the fact that it was her missteps that were creating the response from fans. Press outlets were picking up that she was cross promoting alcohol and her husband's superhero movie and her hair care and beverage lines. And they point out that Lively does not dispute that any of these events actually occurred. She just merely insinuates that the defendants had a role in bringing them to light. So she admits she had missteps, but it's their fault, and it's the reason it got amplified. She claims is because of Wayfair. That's bananas. One of the best paragraphs in this entire thing is the evidence does not support her headline claims. After months of scorched earth discovery, backed up by a pounding drumbeat of almost daily motions to compel, Lively has been unable to identify any instance in which a defendant distributed or promoted any false story about her, even after subpoenaing dozens of content creators. Her interrogatory response, summarizing the evidence of what she described as a highly orchestrated smear campaign, reveals a surprising truth. What Lively primarily objects to is Baldoni efforts to defend himself, whether by promoting positive stories or trying to suppress negative ones. But that is not retaliation. They reference that there's no bots used. So much of this is like what we already know, that when they're talking to the press, they're being truthful. And being truthful is your absolute best defense for any sort of claims of what defamation is, right? So if they're being honest, how is it retaliation, right? It's not. Sometimes honesty and the truth is damaging because you might have behaved badly, right? But it doesn't mean that it's defamatory or that it's retaliatory. They bring up her whole premise of how she created the lawsuit with the Van Zandt. She initiates the lawsuit. So it says Baldoni's natural defensive effort after being sidelined from his own premiere to manage his own and his film's reputation by employing experienced PR professionals has now been recast as retaliation against Lively for raising purported sexual harassment concerns. Lively's numerous claims against numerous defendants cannot withstand scrutiny. Judgment should be entered for defendants on all claims. Now, a large part of what they do throughout this summary judgment is going through the elements of what it means and how you have to prove sexual harassment. And they have to sort of dissect and decide, like go through each point that you have to meet legally in order for it to meet the burden of a sexual harassment claim. So she would have to prove that it's severe and pervasive, that it was targeted on her based upon her gender, and that they didn't prevent it once they knew about it. They didn't remediate it. They didn't correct it. So when you think of it in this context, severe and pervasive, it has to be very severe. It has to be more than a couple of comments about your appearance. It has to be more than some, flippant remarks about your outfit or your pants looking good or whatever it is, your body, the fat shaming, the copying a look with her eyes. It has to be the frequency of the discriminatory conduct, its severity, whether it is physically threatening or humiliating or a mere offensive utterance, and whether it unreasonably interferes with their work performance. Their argument is that her claims are based upon offensive utterances and on set mishaps do not satisfy the standards. They say he twice used the adjective sexy, which they felt was hardly surprising given how sexually charged the film was. This is considered low-level offensiveness in terms of sexual harassment. And then the comments were made when she was not actually, clad in sexy clothes. She was wearing a oversized onesie. It wasn't even flirtatious. And interestingly, aspects of this is that they go directly to what the Second Circuit has ruled in terms of like sexual harassment. So they go to this example and they say the Second Circuit held a high school teacher's claims that her male supervisor occasionally commented on her physical appearance and participated in a bet with 3 other male employees as to when he would be able to engage her in sexually explicit conversations were insufficient. Another example is they say claims that a senior employee told plaintiff that her clothes were sexy and that her hair was beautiful, sometimes blew kisses at plaintiff, as he did to all employees, once sent her an inappropriate email and made sexual jokes, were insufficient. Another one was a file clerk's claims that her supervisor complimented her hair and eyes, commented that she looked good in tight pants, and referred to her as a bitch twice were insufficient. And in order for this to be discrimination, this harassment has to be based on the fact that she's a woman and off of her gender. So they're saying that she has to convince a court that she was treated this way because she was a woman. And that for Title VII, it has to be, you have to be able to differentiate it. Is one sex being exposed to something that another sex is not? So it's only the women that are experiencing this. It's not being exposed to anyone else. And it is because they're women. And they're claiming that some of her claims can't meet that burden because one of her complaints was that there was too much hugging on the set. But she can't prove that the hugging was gender specific. And undisputed evidence shows video footage of both men and women being hugged. Perhaps there was an over generosity of spirit among people on set, but such facially sex neutral incidents, even if they made her subjectively uncomfortable, don't create an environment that it's hostile towards or abusive towards someone on the set or towards women. And the hugging part is crazy because they talk about how the complaint that her makeup artist had was that it was very odd and weird that people hugged so much on the set. And then, in regards to conversations about Baldoni about consent and pornography are things that he speaks about to both genders. It's something that they claim he would speak about. He did TED Talks about it, he wrote books about it. It was something that he didn't target her about those conversations because she was a woman. It was something he talked about with everyone. And they can provide evidence that these are not isolated just to her. In the form of the video, that the birth video, this was shown not only to Heath, but also to Baldoni. So it wasn't just a female that was being shown this video. And then glancing at her doesn't mean that it's sexually motivated. Here's how they frame the film, seeing the birth video, and how they frame what she claims was sexual and what she's saying being exposed to and how it's discrimination. It says that she relies on the fallacious assumption that an unwelcome reference to sex or sexuality is gender discrimination. That's not the law. Exposure to overtly sexual conduct, far more egregious than what that alleged here, is not actionable if not specifically motivated by gender. So it goes into a case of Brown versus Henderson. The court granted summary judgment, and the Second Circuit affirmed, even where the plaintiff alleged that she was the butt of jokes about an affair with a male employee. Her co-employees threatened to sodomize one another, and someone posted a pornographic picture of a naked, obese, spread-eagled woman masturbating. It was undisputed that the plaintiff was subject to unwelcome verbal conduct of a sexual nature, but the court rightfully found that failure to adduce evidence that the conduct at issue was based on her sex is fatal because men were involved in the conversations too, right? So if other men are participating in it and it isn't specific to that they're doing this to her because she's a woman. Another one is that they say dismissing claims by plaintiff bartender exposed to private sex parties and nudity, prostitution, and people performing sexual acts in her presence because plaintiff does not claim that she was subject to these because she was a woman. California Supreme Court reinstated a grant of summary judgment dismissing FEHA hostile work environment claims where a female writer for the TV show Friends presented evidence that male writers for the show had engaged in sexual antics, including their pantomimeing of masturbation, graphic discussions about personal experiences, and preferences in women, bragging about their exploits. They said none of that met the burden because it found both men and women were engaging in it. So if Blake's also hugging, she can't claim it's sexual harassment. If Blake's also making comments that things are sexy, if he's talking to both men and women about what he's telling her, if both men and women saw the birth video, if it has to be that she's being targeted because she's a woman. And then they claim that, they fixed everything and so they remediated it. And then when you look at the biggest part for the retaliation is in order for her to claim retaliation, there has to be an actionable adverse action. And that includes demotion, sidelined, or paid less. And none of those things happened because she got more control. And that there's too big of a window between when she made her claims addressed and they were taken care of by Wayfarer to when the publicity happened, it's too long of a gap between those two things. And it's neither against the law nor retaliatory for Baldoni to put out positive press about himself or to attempt to mitigate or suppress any negative stories that may arise. That's what PR activity is, nor is pointing journalists to pre-existing negative coverage of Lively actionable. And they point to other cases that involved entertainment where it talks about employers accused of leaking false narratives to the National Enquirer. The court dismissed the retaliation claim, holding that any contact with the National Enquirer was not an adverse action under anti-discrimination laws, but rather a colorable defense to protect the defendant's business. They were reasonable defensive measures. And they also note that she can't even prove anything that they've said to the press was false or defamatory. They point out that she's never pursued defamation claims against Jen Abel, Melissa Nathan, the agency group, or any of the PR professionals, and that her other defamation claims are related to what's been done after this lawsuit occurred of statements that Mr. Friedman made on behalf of his clients. Lively has also claimed defendants engaged in a sophisticated digital warfare against her. Although Lively will no doubt assert the facts are contested, discovery establishes that digital warfare never happened. In August of 24, long before this dispute, he repeatedly asked his PR team if they were using bots or fake accounts to foment negative sentiment against Lively, and they assured him they were not. They routinely throughout this go back to the Second Circuit and what rulings have been made within the Second Circuit and what is deemed retaliatory, what is harassment, and did the plaintiff's own behavior contribute to the purported retaliation. And their argument is that she's the one that started the publicity fight, and her reaction to even the hint of any defensive response showed she remained an eager participant on the battlefield. On August 9th, the same day she claims the purported smear campaign began, Lively, I'm assuming it's about what Leslie Sloan did with the Daily Mail, and then there's something else on August 13th. Lively and her team filed a bogus lawsuit in New York State Court and then subsequently worked with the New York Times to publish a 4,000-word article about Baldoni's purported misconduct, based upon numerous private and cherry-picked texts improperly seized from Jen Abel's phone. This aggressive response itself shows media activity transcended not only the workplace, but the bounds of workplace anti-discrimination laws. Then they go into what we've also talked about so many times is like, what is the protected activity here, Blake? What is it that what was the statement that she made? Like, how can she prove that the protected activity was the but-for cause of the alleged smear campaign? And how do you establish this link? Their biggest thing is that they say there's no temporal proximity between any claimed protected activity and the alleged adverse action, because she had no real consequences for at least 8 months after she presented her protections demand, and that once filming resumed, everything was fine. And that's when all of the intimate scenes were actually filmed, and she had no complaints during that entire period. They bring up her testimony, which her deposition is sealed, so we don't get to see that. But even at her deposition, she apparently tried to bring up situations that she had never brought up before and she never filed a claim about. Then they next say that she cannot prove proximate cause. They said it's ridiculous to suggest that for Lively's airing of protections some 8 months earlier, defendants would have hired PR professionals to help manage their reputations. Defendants would have reacted to Lively's onslaught of negative press against them, even if no concerns about their onset behavior had been raised. They had legitimate interest in protecting their reputations and the reception of the film after Lively isolated Baldoni from the rest of the cast and snubbed him from the premiere. They eviscerated any inference of but-for causation relating to the events in the distant past. So his claim, again, repeatedly, is that I hired this because of her doing, again, her behavior. She isolated me from the situation, and that's why I had that. It had nothing to do with these protected activities. I'm sure Blake will come back and be like, well, I isolated you because you're a predator. whatever. Okay, the very next part of in order to prove sexual harassment, you actually have to prove that you're an employee. Okay. And there has to be a power dynamic. And Title VII only covers people that are employees, not independent contractors. And their claim, moreover and over and over again, was that she was not emboldened to any employer. She controlled the terms and conditions of the work she performed to an extraordinary degree. She moved the location of the film, changed the filming schedule, led meetings at her own personal residence, and demanded numerous terms and conditions without which she refused to go forward. If sexual harassment law is designed to address a power differential, her star power gave her the upper hand, and she came to exercise such immense control. So there's a specific list, like checklist they make you do for employers to help determine whether or not someone is actually considered an employee, right? One argument they say is that she didn't sign the agreement herself. It was that she used Blakel, but they look specifically at did she have the right to control the manner and means by which the product is accomplished? She had control at every turn. She reserved the right not to perform in any intimate scenes to which she did not consent. She determined filming location and schedule, took over significant aspects of the script and editing. She refused to move forward, including when presenting her list of protections, unless others ascended to the terms. Was a high level of skill required for her work? Yes. Lively was an A-list actor. She touts many skills and accomplishments in her letter to the PGA. She bargained for a 1.75 million guaranteed payment, as well as additional bonuses, including a box office bonus that was required to be no less favorable than Baldoni's. Who was the source of the instrumentalities and tools? Lively herself was the primary instrumentality of acting work that she performed. Wayfarer arranged for the set and paid for the ancillary materials, but she made decisions and exercised creative control, and she claimed credit for it. Remember how I said that she was on the red carpet claiming all of these, I did this, I did this, I did this, and I said that's going to work against her. I think that's probably what that's going to be. And then who chose the location? She told, again, I'm assuming the PGA, she insisted shooting the switch from Boston where the film was set to New Jersey. That was a location more convenient to her home. And they keep referencing her PGA letter. And this is going to be a huge factor because in order to be a PGA, it asserts that you actually have control over the film set and that you're the one in charge, which again strips her, I was this weak employee at the behest of these evil Wayfarer, my evil Wayfarer employers. What was the duration of the relationship? Could any defendant assign additional projects to Lively? They said no, because it was limited to the scope of that single project. Did she have discretion over when and how long she would work? Yes, that was an extensively negotiated aspect of her offer letter and never executed loan out agreement. What method of payment was used? Her loan out entity was paid by minimum guaranteed payment in a sixth installment pursuant to an escrow agreement, which with additional bonuses contingent on the film's success. Was she in the role of hiring and paying assistants? It was extensive. What was her role? She claimed personally in her PGA letter, that's going to come back to bite her. Under this unexecuted ALA, she would have also had the right to select her own personal assistants, nannies, and security. Were defendants in business and was the work part of the regular business? Yes, defendants were in the business of producing films, but it was not as if Lively walked into a pre-existing business and simply followed their rules. By her own account, she transformed the entire production process and she took control. Did she receive employee benefits? No. How was she treated for tax purposes? Not like a standard W-2 employee as required by New Jersey law for films shot in the state, withheld a tax, but they didn't pay any of her other taxes for federal, state, or income taxes, Social Security, or Medicaid. So she had to take care of that all of herself. They claim that the failure to investigate claim she can't prove and she can't win because they really had nothing to investigate. Because once she brought the claims, the protections were applied and everyone was happy. And after everything was done, she agreed that everything was great. So what did they have to actually investigate? Nothing. She never made a formal claim or to HR. The next part is going through the contract and could they actually breach a contract that was never signed? And now I see why they didn't amend their complaint. but they're saying that the contract writer agreement was incorporated into the unexecuted actor loan-out agreement and was therefore subject to the same unsatisfied conditions and incomplete formation also, and was not independently supported by valid consideration. And even if they are enforceable, her claims would still fail for multiple reasons. So they're going to go into, we don't believe it's enforceable, but if it is, here are the other reasons. One argument for why it's not enforceable, they say the undisputed facts show that the parties communicated an intent not to be bound absent full execution via the clear condition precedent language in the draft of the ALA, which IEWM refused to remove. Their continued efforts to obtain her signature through July 24 and her continuing refusal to provide it as a manifestation of her acceptance and the entire agreement provision of the draft ALA. So she never signed it. So how do you enforce what is not signed? And because it's incorporated in there, how do you claim that you breached something that you failed to actually sign the bigger agreement? And it says that it's not because of their negligence that it wasn't signed, because they were doing everything they could to get her to sign. The undisputed facts established that the parties continued to negotiate material terms until July 24, and no final agreement was ever reached. And then they say the only thing that they could arguably argue that is enforceable would be her offer letter, which was fully negotiated and agreed upon in May of 23, but not the actor loan-out agreement, and the terms of which were never finalized. And they don't dispute that consistent with the offer letter, it placed her upfront fee into escrow. And accepted services on the first phase of filming. The offer letter does not contain the provisions that Lively says were breached. Thus, whatever the validity of the offer letter and Lively's right to enforce it, that letter cannot be salvaging her fatally defective breach claims, and that you cannot enforce the contract writer agreement because it was made part of the actor loan-out agreement that she never signed. It was never intended to be a standalone agreement. Rather, by its terms, it was provided additional terms and conditions in connection with the artist's services. And you remember how I brought that up about, I thought it was executed because she signed, but if I look at it from this view, I can see where I might have got that wrong, because if she didn't sign this entire document, how do you enforce something that's a side agreement to it, right? Nothing in this suggests that it should be enforced independently of the unexecuted actor loan-out agreement. The very existence of it demonstrates that the parties were still negotiating the ALA and seeking to amend and supplement its terms. The CRA's plain text shows it was intended to be integrated as part of any final ALA, but there is more. The conduct of Lively's counsel confirms the parties understand that even though the CRA was finalized first, the CRA was to be an ancillary amendment to unfinalized, unexecuted ALA. A lot of the contract law is basically just that, one, their arguments is she never signed it, and then the other goes to, okay, even if we take it as fact that it is signed, here's why we can't enforce it. And they have a lot of different ways for a judge to look at this, which is really what it's about. It's like he's going to give you he might not agree with everything here because this is their argument to the judge. So he might say, okay, I don't agree with this. And then, so their next option is that, well, okay, even if it is enforceable, there was stipulations within the contract and she didn't give us proper notice, or, she can't actually claim that she notified us because if she did, we cured all of these issues. Like there was a part of this contract that said that they had to give 30 days notice from the time that the complaint was made. And then the company Wayfarer or It Ends With Us, had 30 days to fix it. And if after that it wasn't cured, then legally they could go to, arbitration or whatever it was. But then they also bring up that there's no such Wayfarer was not the contract employer, quote unquote. It was It Ends With Us, and she can't claim that Wayfarer was an alter ego. And they go into this lengthy description about how it's common in the world of production that the studio would have a separate company for a film. to separate the liability as well as to separate the finances of it, because a studio is dealing with many different films. And in order to manage the film's budget, they do it under one separate company. And so they again point out that she didn't properly sue It Ends With Us. She's suing Wayfarer, who's not the alter ego here. There's all these other parts here that are related to her damages. And then there's issues within their contract about what kind of damages she can claim. One of them being that she can't get punitive damages and these triple damages because it's actually barred under her contract. And their other aspect is that, like, the damages she's claiming about lost profits and lost wages and reputational harms, none of that is within our contract, because your contract was for a specific time period, a specific moment, a specific project, and everything else out here are excluded under this provision of your contract. And then she claims that her contract claims are duplicative of the sexual harassment claims, and they're duplicative of the other claims that she's making. So she's attempting to get double recovery, which is barred, they say, under the law. They go into the defamation claims, which, again, their argument for that is that these aren't defamation claims because they're defending themselves. And you can't claim that speaking and defending yourself after a lawsuit is filed is actually retaliation. And it's all protected under litigation privilege. And they want New York law for that. And then they say that no false light that fails as a matter of law. So they're not abandoning the arguments that they made for their judgment on the pleadings. And instead they're saying, like, this fails as a matter of law because false light isn't even a claim in the state of New York. And then the conspiracy claim, they also, for the same reasons, basically say everything else is removed. There's no conspiracy. And then they go into some of these damages that she's claiming. And that, first off, Sarowitz has zero to do with this. He was barely on the set. He is the financer of Wayfair Studios. And she can't even tie him to this film. They bring up the claims of his statements. He's going to spend $100 million to ruin Lively and her family, but there's no record that he ever said that. And all he said, he was going to defend himself in the studio, and that he really didn't want to ruin her because that's not the world I want to live in. And that the dead bodies comment was taken completely out of context. And then as far as, like, what she's looking for damages, this was not related to their contract. Again, it's associated with profits of two non-parties, which, remember how I said that you can't claim damages for non-parties because these are businesses that she has a stake in, but it's not her. And she can't claim that this is her alter ego because she's not the only person involved in these businesses. She can't claim speculative lost profits because these are brand new businesses and it's based on, like, what someone thinks that she's going to be able to make. It's really just saying that, like, she's claiming damages for people that are not a part of this lawsuit. She's an indirect shareholder of these entities, and they are not. She has no such basis to claim any such damages or to recover losses allegedly suffered by these entities. Blake Brown and all of these companies that she owns have nothing to do with it. It Ends With Us, and they're not parties to this lawsuit. They're not suing them. And they already say that courts reject claims that where an individual seeks redress for corporate damages, and that she can't recover again. Yeah. And then for all of those reasons, they're saying this needs to be entered in the favor of Wayfair against Lively, and this case needs to be completely kicked out of this court. This summary judgment brings up so much of what we've talked about here on this channel this entire time and this podcast that we've been covering this lawsuit. Our arguments have always been, is this really sexual harassment? Is it as severe as she's claiming? Is it pervasive? What was her protected activity? If this is the protected activity, how is retaliation a year later retaliation? What was the adverse action that occurred? They're saying there is none. What is the contract that she was violated? Were they even in a contract? She's not our employee. We were never her employer. She never signed a contract. Remember how I said that the contract was going to come back and bite her in the ass? And remember how I said that the PGA stuff was going to come back and bite her in the ass? All of that was used here because her control obliterates the concept that it was a unequal power dynamic. You can't claim that you did the whole video and you controlled the set and you did this, and you can't write a letter to the PGA and said that you were in charge of this film and then claim that you were the employee that was harmed by sexual harassment. You can't have it both ways. Now, do I think that that Blake is going to come back and try to say we need to go to court because we don't agree? Yes, I 100% think that their response is going to be that they don't agree about any of this, right? I think they've been given to the court 237 exhibits, hundreds of pages, over, I think, almost 1,000 pages of exhibits to this court of evidence that they say proves that this is undisputed. Lively's job is going to have her own exhibits where she's going to say, no, this is what we have, this is what we're doing. But what I noticed in all of this is that Lively didn't file her own summary judgment. She said that she was going to for a very long time, and she never did. So she's not saying she won. They're putting it all out there. She's going to fight back 100%. Will all of these arguments persuade the judge? No, they won't. That's just the facts. Not everything that's argued will be persuasive. Not everything that they bring up will be persuasive. Is it enough? Do they give them enough alternatives? Maybe. Between this and the judgment on the pleadings, there's two separate dispositive motions that can kick this out either on the basis of there's no undisputed facts and we have no disagreements here and there's no legal issues that you need to resolve, and this is really just a game of reputation, or this doesn't even meet the burden of the law for these pleadings. The judge has two separate ways to get rid of this case. And if I'm a betting person, I'm going to guess that with the given amount of evidence, that if this does go to trial, if it goes to trial, it's going to have like two causes of action, tops. I do think a large part of this case is going to end up getting dismantled either through this or that. And she now has to respond to both. So on the one hand, she's going to have to say, I did plead this on law, and this does meet the pleading requirements. And then on the other hand, she's going to have to say, and I have disputed facts. They're in opposite to each other. So it's a very challenging place to put herself, and a precarious place to put herself in. And in the way that the Wayfarer parties addressed this is they tackled it from two angles. So they're not arguing FEHA should get thrown out based upon the fact that it's extraterritorial. They're just saying it doesn't even apply. So he can agree with it doesn't apply extraterritorial, or they can agree with it just doesn't apply because she wasn't our employee and we had no contractual relationship with this woman and there was no adverse actions that occurred. And Blake's truly own retaliation that she can allege here is that Baldoni and Wayfarer defended themselves. And she's trying to take away their First Amendment claims. And this is all about reputation. Now, there's 1,000 pages here of exhibits that we need to go through in other videos. And this video is long enough, but that's the meat of the summary judgment. I think it was an excellent job. I like that they brought up that there was no adverse employment action. I like that they went through the contract and the issues with the Blakel and the alter egos. And I love that they addressed the issues with the damages, about how you can't claim damages for businesses that aren't you. So Blake is going to have her hands full. And I really love that they called her out for her incessant use of the docket to completely yell and scream about how awful these people are, which is, again, not typical in a lawsuit. This was, and obviously, most importantly, how they addressed the sexual harassment claims. Was this and does this meet the requirements for sexual harassment? And point by point, they argued no. And I think those arguments will be persuasive. Months and months and months of Wayfarer just taking everything in, and now they're just dumping it all out and they're saying, here, judge, you decide. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Please make sure to subscribe to my channel if you haven't subscribed. If you want to support the channel, you can make sure to click the bell so you never miss a video. Make sure that if you'd like to send us thanks to support us financially, you can send us donations through the thanks button, the heart, and also make sure to send some hype. Make sure to sound off below. Bye, besties.